The last topic we need to address are what the brokerage relationships are here in South Carolina. Now, really, what we're getting ready to go over in this module is really just review, okay? Because we talked about the different types of brokerage relationships, agency relationships, transactional brokerage, that kind of stuff in one of the earlier chapters throughout the course. But there really shouldn't be anything in this chapter that you really don't know. So it's really, again, this is just a review is what this is, but it's also to let you know what types of relationships are legal in South Carolina, because we actually talked about some types that may be legal in other states, but you need to know what they are, because they could be testable. They could ask you about those types of relationships that other states allow, even though we don't. It could be on the national portion of the exam, so you need to know what it is. And again, we've already addressed that in an earlier chapter. So again, this chapter is just for review and to make sure we understand what are the legal or permissible forms of brokerage relationships in South Carolina. Start out with the fiduciary duties. Make sure you know these fiduciary duties. I promise you this will be on the exam. You're required by law to provide them. How in the world can you say that you will provide them if you can't even tell me what they are? So you need to know what these are. You see them there. We've been over them before. So just make sure you memorize those duties, because you're going to get questions about them. Wholesaling. We talked about that too. In fact, that wasn't too long ago. I don't think we talked about wholesaling. But we know, bottom line, in South Carolina, wholesaling is now illegal. Remember, that's a no-no. Now, they kind of went a long way around. I say the legislature kind of went a long way around trying to make it illegal, because basically they wrote the law saying that you now have to have a real estate license in order to wholesale. Obviously, you can't, if you're not licensed, you cannot wholesale in South Carolina. But then they put in the law that it is illegal for real estate agents to practice wholesaling. Okay, so at the end of the day, even though they went the long way around, wholesaling is illegal in South Carolina. And again, we talked about that. In fact, that might have been in the couple of chapters ago, but if you don't remember it, you can look at it. But primarily it's just when you put a house under contract and then assign the contract to somebody else to let them buy the property for a fee. Again, that's now illegal in South Carolina. Some states do it, some states it's legal, so obviously you need to know what it is. So what are the legal relationships in South Carolina? Obviously there are 5 of them. Seller agency, buyer agency, dual agency, designated agency, and transaction brokerage. That's it. Just for example, another form of agency we talked about in the national portion was implied agency. That is not legal in South Carolina. Some states do it, and it's okay in those states, but not in South Carolina. Those are the only 5 that you're allowed to do. In fact, my guess is they will ask you a question. Which of the following brokerage relationships are legal in South Carolina or not legal, for example. So make sure you know what's legal in South Carolina. But then we look at, under these brokerage relationships, just some things the law addresses that, again, should be just a review. But we know the broker in charge has to write and adopt a written office policy manual. And in paragraph B specifically saying, the broker in charge is responsible for determining what forms, documents, contracts will be allowed to be used by licensees within that office. And then that must be in their policy manual to make sure that they've in fact addressed that. In paragraph C, the law says all agency agreements must clearly lay out the services you're going to provide to the seller or potentially the buyer. But you can't just say I'm going to represent you and not say what you're going to do. What does that entail? You got to list it out there. Make sure it's all included. And then in paragraph D, it's just saying licensees acting as a seller's agent may offer alternative properties to prospective buyers as well as listing competing properties for sale. In other words, if I'm representing a buyer and you need to tell them this, buyer, you're not the only buyer I'm working with. I got other buyers also looking to buy, and it is possible that there might be another buyer interested in the same property I'm showing you. Now I'm going to represent both of you fairly. I'm not going to tell either one of you anything about the other. But you just got to let them know that you're not the only buyer that I'm working with. And so in a situation like that, potentially, I could have you and another buyer actually competing for the same property. And again, that's just part of business. But now you better make sure you treat both of them fairly, honestly, but also you got to disclose to them that is certainly a possibility. All right. Then in paragraph E, this is where it says you better lay out in your buyer's agreement what you're going to do for the buyer. And and this is in paragraph F is really saying the exact same thing I just talked about. Actually, I was talking about if you're working with two buyers, but on the previous slide it was if you representing two sellers. I might show the same buyer at both houses, even though I'm representing both sellers. Seller, I'm going to do my best to sell your house, but I can't not just show your house. I got to be able to show other houses as well. And again, all that's just part of doing business. In paragraph G, it says we must disclose all known defects to buyers. Now, just again as a review, is this just if the buyer is a client? Or do you also have to disclose defects to customers? I know I addressed this earlier, but again, that's for all buyers. It does not matter whether the buyer is a customer or a client. If you have knowledge of any issues or defects with the property, you must disclose it. It might not even be your buyer. It might be the buyer. Maybe you're the listing agent, and another agent bringing a buyer. You better make sure that buyer's agent and the buyer knows about any defects that you have knowledge of. Now, it does go on and say that, as the licensee, you're not obligated to discover defects. Again, you're not a contractor, so you don't have an obligation to inspect the house yourself to look for defects. Again, it's just if you are aware, if you have knowledge of it, then you must disclose it. And then it also says that, is it possible a home inspector misses something during the home inspection? And maybe something major. I'm telling you, it happens. It happens. And it doesn't necessarily mean you got a bad home inspector. It probably means they had a bad day, for sure, if they missed something major. But at the end of the day, what it's saying here, you can't blame me or the agent for something the contractor did. So when they prepare their home inspection report and they left something out of it, maybe because they forgot to put it in there or never caught it, didn't realize it was an issue, that's not my fault. Okay, I have no control over what any contractors do. And then this third bullet here, it says licensees cannot be liable for providing false or misleading information if the licensee did not know the information was false or incomplete or whatever. Now, I will tell you, you better be careful with this one. Because, a lot of times agents will provide false information or misleading information and then claim they didn't know it, when in reality they probably did. And that's unfortunate. You got people like that in every type of business. So, if they can show that you did have knowledge of the problem, you're going to have a problem. Okay, so just be careful with that one. And then in paragraph H, we just talked about in the previous hour, well, actually a couple hours ago, the buyer has an obligation to inspect the property. Now, the law does not require the buyer to inspect the property, but the law is very clear. If you pass on your obligation to inspect the property and then move in and find problems, and then want to say, well, the seller never disclosed it, well, maybe the seller didn't know about the problem either. But at the end of the day, if you never had it inspected, you pretty much waived any legal rights you have to go after the seller if you discover problems later. So, I'm just telling you, I think buyers need to have a home inspection. If for some reason that buyer says they're not going to do it or don't want to do it, again, they don't have to. But I would make sure, if it were me, I would have them sign something acknowledging that I recommended it. I highly recommended it, and you chose not to. Because I'm just telling you, if you don't do that inspection, you're almost pretty much waiving a lot of rights that you might have if you discover problems with the house later. So just beware. In paragraph I, we know dual agency is legal in South Carolina as long as we have the written informed consent of all parties. Designated agency is also legal with the written informed consent of all policies or of all parties. But we got to make sure also, if you're going to allow dual agency or designated, or if it's going to be allowed in your office, then make sure your broker in charge has addressed it in their policy manual. Because in their policy manual, it has to state what types of relationships this office will allow. We know there are 5 legal forms of relationships in South Carolina. But I'm telling you, not every office will agree to practice all 5. For example, some offices or companies say, well, we'll represent buyers and we'll represent sellers, but we will not represent the buyer and the seller in the same transaction. In other words, you're saying we will allow buyer agency, seller agency, but we will not allow dual agency or even designated agency. There are a lot of companies that say we will not allow you to practice transaction broker. So again, just because there are 5 types of relationships that are legal, it doesn't mean that every office has a policy agreeing to let you do that. So make sure you know what's in your company's policy manual when you decide on which office you want to hang your license with. All right, and then in paragraph K, here's just saying licensees may represent one party while offering ministerial acts for a customer in the same transaction. In other words, could I be representing the seller in an agency capacity, but just working with the buyer as a customer, not representing them, just providing ministerial services? I can do that. Not a problem there. We know transaction brokerage is legal, right? Again, that's a legal form of relationship. Again, but before you decide to get out there and you're going to do it, you better make sure it's okay with your office. Because I'm telling you, a lot of real estate offices do not like transaction brokerage. A lot of them. And when I say they don't like it, that means they're not going to let you do it. And if you get caught doing it, that's the same as violating the law. Remember that policy manual is an extension of license law. That's what it is. All right. But anyway, so we list some things here that indicate what services shall be provided. And what the law is saying here, if you are going to agree to work with the customer, obviously that means you're a transaction broker, then here are some things you shall do. These are not suggestions. You must be fair and honest. You must account for all their money, all their funds. You must use skill, care, and due diligence. You still have to disclose material facts. You must promptly deliver all offers, and you owe that customer limited confidentiality. I'm telling you, big difference between owing someone confidentiality and limited confidentiality. If they're your client, then you owe them full, complete confidentiality. But that's not the case if the person you're working with is a customer. So what is limited confidentiality? Well, here you go. You cannot disclose what the buyer's motive or willingness would be to make a high offer. You cannot disclose the seller's motives and the willingness to accept a lower offer. And you cannot disclose whether the buyer or seller will agree to financing other than those offered. You cannot. Those are the things you're limited from disclosing, for buyers and sellers. That's it. That's what the limited confidentiality covers according to the law. But then in L3, it's just saying, when you are working with customers, here it lists what a transaction broker may do. You may identify and show properties for sale. So, and I've heard people say that, or ask, can you show property for sale to a customer if you don't have a written agreement to do so? Yes. You don't have to have any signed document to be a transaction broker, and it says right here in the law you can. Let me just, as a side note here, when you hear, or because you will, you're going to hear some people saying you cannot show property for sale to anyone that has not signed something. You must have a signed piece of either a transaction broker agreement or an agency agreement, or you cannot show the property. That is not what the law says. Now, where they're getting this from is from the Association of Realtors. There's the Association of Realtors, has put in their code of ethics that realtors must have a signed agreement before they can show a property for sale to a customer. Now, again, that's the code of ethics. And I'm not saying anything's wrong with that, but you're not going to be tested on the code of ethics. You're tested on license law. So the law says right here, you can show and identify property for sale. You can also provide statistics and information about the property, like tax information, stuff like that. You can provide pre-printed forms, contracts, documents, things like that they might need. If they wanted to make an offer, you can certainly provide them with a contract sale to make an offer on. You can act as a scribe in actually preparing the documents. Now, where you got to be careful, in fact, all of these things here you better be careful with. Because I'm telling you, there's a very thin line between doing any of these things here and crossing that line and doing something you're not allowed to do for a customer. You remember, you cannot provide any form of representation to a customer. All you can provide would be ministerial services. And if you cross the line and go too far, or say something that goes too far, if you offered your opinion about something, which is a no-no, Y'all, you cannot offer your opinions or suggestions. Y'all, those are considered professional services and can only be provided to clients, not customers. So if you're not careful, you can cross the line here and create an implied agency. And we just talked about that. We know that is illegal in South Carolina. But y'all here are saying you can act as a scribe. So if this customer wants to make an offer, then I can say, all right, well, tell me what you want to offer and I'll write it up for you. But just understand, I'm going to write up exactly what you tell me to write up, whether it's a good idea or a bad idea. And is it possible that I know from my experience this is going to be a bad idea to do what you're asking me to do? This is not going to work out well for you. Is it possible I know that? In fact, very likely possible. But can I tell that customer this is a bad idea? No. Because now you're crossing the line. So again, don't add on here to what the law's saying you can do for customers. You start adding on to any of this stuff, you're going to create that implied agency and you're going to have a problem. You can provide a list of potential contractors. Oftentimes buyers will say, well, yeah, I do want to get a home inspection, but I don't know any home inspection or home inspectors. Frankie, do you know somebody you could suggest or recommend? Sure, I can do that. Or maybe they say, well, I don't know any real estate attorneys around here to do the closing. Could you recommend an attorney? Sure, I can do that. Whatever. I can recommend, I say recommend, I can provide options or potential contractors do whatever they need to be done. And then lastly, I can identify where schools are, churches are, shopping centers, stuff like that. And I'll tell you, that's very common. I know a lot of people say, well, I understand if we buy this house is zoned for such and such an elementary school. But I don't know where is that school? I don't know where they are. Then, assuming you know where the school is, then you can certainly tell them where the school is located. Nothing wrong with that. All right. But then we look at, again, when working with customers, what you shall do. Again, on the previous slide, things you can do. On this slide, things you must do, which we, quite frankly, we already talked about a lot of this, but again, it says you must timely present all offers. You cannot procrastinate. You still have to account for their money. Just because they're not your client don't mean you can steal their money. You still have to provide an explanation of agency relationships. You got to explain the difference between being represented as a customer versus representation as a client, and then let them choose. You still got to explain the differences. You got to provide an explanation of the services. If you choose to be a client, here's some of the things that I can and will do for you. But if you're a customer, here's all I can do for you. Again, they got to, the more information you get them, the better decision they can make here. Got to be fair and honest. You got to keep their information confidential, at least the limited confidentiality, and make sure you disclose any known material facts. Now, when it comes to the disclosure, we keep talking about that. And I'd pay attention to this. This obviously will be on the exam. And you're going to be doing this day in and day out if you're doing things right, excuse me, when you're practicing real estate. But if you look at paragraph A here, it says a licensee shall, again, that doesn't sound like a suggestion to me. You shall provide at first practical opportunity to all buyers and sellers of real estate with whom the licensee has substantive contact. The law lists two things you must do at first substantive contact. Now, first of all, what is substantive contact? As soon as the conversation turns to real estate, Y'all, but if the buyer is wanting to talk about potentially buying a house, or a seller is thinking about potentially selling their house, they want to talk about it. Y'all, you got to stop them. Whoa, time out. Two things you got to do before you can allow them to continue with this conversation concerning real estate. Y'all, that's what substantive contact is. Y'all, you don't have to start disclosing agents and stuff every time somebody comes up to shake your hand. But if the conversation turns to real estate, now y'all, by law, there's two things you have to do. And number one, it says you must provide a meaningful explanation of agency relationships in South Carolina, along with the services you're willing to offer to either customer or client, which we just talked about that. So basically saying you must basically you got to tell that, say it's a buyer you're talking to. Y'all, before you get into any meaningful discussion about real estate, you got to stop and say, all right, well, before going any further, let me make sure you understand something. In South Carolina, if you buy a house, assuming you use the services of a real estate agent, you have a choice to make. You can either be represented by that agent either as a client or a customer. And then you need to explain what's the difference between the two. And basically you're saying, if you're a client, I can do this, 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 and this, which might include I can offer my opinions, my suggestions. I got to keep all your information confidential. I got to provide all these fiduciary duties. But now if you decide to be a customer, I can't do any of that. I cannot represent you, and I cannot keep anything you tell me confidential. Y'all, which by the way is why you must stop somebody at first substantive contact. Y'all, you can't let them carry on a conversation, and before you know it, they'll be disclosing confidential information to you, and you can't keep it confidential if they choose to be a customer. So y'all, you got to stop them. And basically, I know this sounds kind of weird, but in essence, y'all, you got to read them their rights. Y'all, you got to Mirandize them. All right, I'd be glad to help you and talk to you about real estate, but before we do, I need to read you your rights. And this is what you're doing here. Y'all, because if they choose to be a customer, you need to tell them up front. Don't tell me anything you wouldn't want the seller to know about. And I will tell you about the first thing the buyer is going to say. Well, we're looking at buying a house, and about the most I can get approved for is $200,000. I mean, I can't get approved for any more than that. Do you think you can help me find something that I would want for no more than $200,000? Well, first of all, do you think that would be confidential information on how much they can get approved for? Do you think sellers would like to know how much that buyer can get approved for? You bet they would. Y'all, that is confidential information. So you got to stop this conversation before it gets to that level. Read them their rights. Y'all, that's what they're talking about here. Now, the second thing it says you have to do is you must also provide a brokerage disclosure form. Y'all, a brokerage relationship, which is really like a brochure, if you will. In fact, you see there's a copy of it in your book. We're not going to go through all of it, but I'm sure you can't wait to look at that brochure yourself and read it. But basically what that brochure is doing, y'all, it's describing the legal forms of relationship in South Carolina and what they are. Okay? It's just you need to explain it to it, because y'all, most people will read it and they probably won't understand most or any of it. So you need to explain it to them. Y'all, that's what number one was telling you to do. Now you got to provide a clear explanation on what all this is dealing with. But y'all, this brokerage relationship form, y'all, again, same one in your book. You'll notice on the second page of this document, at the bottom of the page, there's a place for whoever you're talking to sign. Now, do they have to sign this document? Yes. They have to sign this document. But what you need to make sure they understand, because y'all, some people say, "Well, wait a minute, no, I don't want to. I'm not willing to sign anything yet. I'm not even sure I'm going to be working with you." Okay, well, first of all, this is not a contract. In fact, if you look right there in that highlighted area on the form, right beside where you'd sign, it says this is not a contract. Y'all, all you're doing by signing this document is just acknowledging that, number one, I gave you a copy of this brochure, and number two, I explained to you what it's saying. And I'm required by law to provide this to you, and by law, I have to keep a copy of it in my file as proof that I did what I was supposed to do according to licensed law. So y'all just let them know, make sure they understand this is in no way a contract. It says it right there by the signature. This is not a contract. I just need you to acknowledge I gave you a copy of this form and I explained to you what's in it. That's all you're doing there. That's it. Now, is it possible you could have somebody say, I'm just not signing. I ain't signing nothing. I guess they could. I don't recall ever having that issue before, but I guess it could happen. But y'all, if they're not willing to sign that, do you really need to carry on a conversation with them anymore? Y'all, they just want to use whatever they can get out of you. They in no way want to be obligated to you, right? So if I were you, I would just say, well, you know what, I wish you well. If you have any prayer requests, let me know. I'd be glad to pray for you. But other than that, this conversation is over. Hope you have a good day. Be nice, be polite, and move on. And if they do have prayer requests, make sure you pray for them. All right. Paragraph B, y'all, it says we must acknowledge receipt. Y'all, that's what we were just talking about. Y'all, meaning they must sign the document. And C is just saying, y'all, when you initially contact someone or conversation ensues, y'all, at first substantive contact, is that person considered a customer or a client? Y'all, hopefully you figure that out real quick. Y'all, they're a customer. Everybody is a customer initially. And if they're a customer, that means you are a transaction broker. But wait a minute, what if my company won't allow me to operate as a transaction broker? Well, you don't have to operate as a transaction broker. Basically, what you're saying is that in order for me to help you, buyer or seller, then you would have to agree to become my client and allow me and my company to represent you. And to do that, you would have to sign an agency agreement. And if you're not willing to do that, then there's nothing else I can do for you. You just have to tell them that. Okie dokie. Y'all, in paragraph D, y'all is just saying if that first contact or conversation takes place, say, by phone. You're not face to face, or maybe it's by email or whatever. Then, y'all, I would tell you the same thing. Y'all, the law is saying the same thing. Y'all, until you get that signed brokerage brochure signed, y'all, you don't know what you can tell them or what you can even discuss with them, right? Because depending on whether they choose to be a customer or a client will depend on what you can do for them, what you can discuss with them, and so forth. So, y'all, you got to do this up front. And, y'all, and I will tell you, y'all, even if they're on the phone, you can tell them, hey, look, if you'll give me your email address, I need to email you this brochure. I can send it to you real quick. Now, there is a place for you to sign, and y'all, I can send like DocuSign. Y'all, there are a lot of e-signature programs out there, but DocuSign, just for example. And before I can really get into any more discussion or conversation with you, I need to explain to you what this is saying, and then if you don't mind, I just need you to sign that form, just acknowledging that I explained this to you, and then we can carry on our conversation. Okay? And then E is just, again, saying no brokerage relationship can be assumed. Again, it must be in writing, because we know implied agency, again, is illegal in South Carolina. Y'all, F is just saying compensation does not determine agency relationship. In other words, could a customer, say you got a buyer wanting to buy a house, but they don't want to be represented. They want to be a customer, but they want you to help them. Could the buyer still pay me to help them as a transaction broker without creating an agent's relationship? Yep, that's what it says right here. You can do that. But then in paragraph G, y'all, here it lists 2 times when you do not have to disclose the brokerage relationships, okay, when it's not required. And they like to ask this question: which of the following instances or circumstances would not require one to disclose brokerage relationships? Well, one reason is if the transaction is regarding a rental or lease of a property. Also, if it's a tenant, you don't have to go over agency with a tenant. And then number 2, if the communication is a solicitation of business. Also, in other words, if I'm doing any marketing or advertising, or I put stuff on Facebook or social media, trying to create some business. Now, you know, there are some requirements if you're going to do that, like the full name of the company you represent and so forth. But you do not have to explain agency or other brokerage relationships in your marketing. You know, that's what it's saying here. Now, if somebody contacts you as a result of the marketing and want to talk to you about buying or selling, y'all, now you have to disclose the brokerage relationships and make sure they understand it. Okay. And then lastly, when it comes to terminating agency relationships, and and you see in your book that there's several ways to terminate agency. We talked about it in an earlier chapter when we were going over these relationships as well. But the main thing I want you to know here, even though agency's terminated, which by the way, when agency is terminated, when that contract is terminated, all your fiduciary duties you owe that client also terminate, with the exception of 2. There are 2 fiduciary duties that will never expire. And I suggest you know what they are. But obviously that would be accounting and confidentiality. Those 2. Now, first of all, what are we accounting for? Really 2 things. Money, and 2, documentations, paperwork. You got to maintain these files for a minimum of 5 years. Okie dokie. Well, that's you now know it all. You should be an expert in real estate now, assuming you've gone through and listened to all the videos. We've covered it all. That's everything you need to know for the exam. How about that? We made it to the end. Praise God. I hope you're going to give thanks to Jesus, because you're not smart enough to do this yourself. But he can do it, and he can make you very, very successful. Thank you, Jesus, for that. And we appreciate you choosing the Real Estate School for Success. Got to take that final test here to get your certificate. We'll get that knocked out. And then hope to see you out there in the real world. And let's go sell a house together. All right? Take care.